the indictment is
the description of it. Yeah, the description of what happened. He posed
for a photo released on someone's Instagram account displaying gang tattoos with YSL on his chest and Slime for Life on his right arm, an overt act in furtherance of the conspiracy.
Right, okay. And the language, the language further shows how he is furthering the conspiracy.
How is that furthering the conspiracy?
Chasing that money, but his past chasing him suggests that he not only does things or has done things that perhaps in chasing that money they're not legal. He is continuing to chase that money in ways that are not legal.
Wait a minute. I thought y'all said the state filed a new motion to get the evidence in that they had. And it's the evidence? I thought we was having a paperwork party. You might as well cancel that party. Objection. Relevance. Let's dig.
What suggests that he is doing anything illegal by chasing that money?
Your Honor.
Isn't that what pretty much all of us who aren't independently wealthy have to do every day of our lives?
If you're new, make sure y'all hit that notification bell, that like, share, comment, and subscribe. Grab a seat. We finna dig deep.
What's up, YouTube family? Welcome back to the channel. I'm your host, Jay, and man, y'all know we back with another twist in this Young Thug yslricotrial. But before we dig deep, if you ain't subscribed to the channel, definitely tap that subscribe button, hit that notification bell so you'll get the drops whenever we drop. Y'all ready? Let's dig. Now, first and foremost, court resumed today with no jury present. The jury actually won't be back until next week, which in turns leaves us with the defense versus state versus the judge. And man, with the state filing the motions over their evidence, ask yourself, again, was it just a waste of time? Now, I did hear that there was supposed to be a paperwork party, but ask yourself, was that paperwork party just a distraction? Let's dig.
Take the easy ones first. The state's motion in limine about overruling whatever objection the defense might ever offer to evidence on the basis of 403 waste of time and the defense response in opposition thereto. I am ruling for the defense on that one for all of the reasons stated in Mr. Weinstein's response in opposition. Takes care of that one. In limine by the state to revisit the court's ruling excluding State's Exhibit 528Y. I have considered that, and I will not be changing my ruling on that. The couple of uncharged post-indictment intrinsic acts that were still outstanding. I've got one question on the circumstance that involved Mr. Ryan and the fight. And I can't remember which co-defendant, but there was a co-defendant who entered a guilty plea and attested to a conversation having been had about protecting a YSL member in the jail and hurting somebody else. What was that about? Do y'all remember that? Did that have anything to do with this? Or were those unrelated?
That was before this.
Okay. All right. Okay, so the court has determined that neither the Ryan situation nor the alleged passing of Percocet to Defendant Williams in court meet the requirements to be an intrinsic act, and so I am not going to admit either of those. And I've also thought again about my ruling out the Stillwell situation of some contraband being in his cell, and I'm going to stand on my ruling with regard to that as well.
So as you see, the judge came in playing no games. 1, 2, 3, 4, 5. 5 motions actually already denied. Not even 2 minutes into the trial day. Man, did the state actually tick the judge off with that motion? Let the evidence in. What evidence? We're looking for the relevance, and you arguing over evidence. Show us relevance. And they said we was having a paperwork party. 403, objection, Your Honor, waste of time. If you threw that paperwork party, was that a distraction too? Let's dig.
One question I saw in my notes, something about the search for Attorney Johnson, the search of Attorney Johnson's laptop. and something that Defendant Williams had requested with regard to that. Can you, Mr. Steele, refresh my memory on what that was about?
Yes, can I have just 1 second?
Sure.
He was asked by Prosecutor Hilton about a jail call, and the jail call had something to the effect of, when Mr. Winfrey comes home, he will be given a Porsche and $250,000, something to that effect. And Ms. Hilton then asked Detective Racy, within approximately a month from that time, that jail call that the jurors just heard, did in fact Mr. Winfrey enter guilty plea? I objected. That guilty plea was vacated and found to be coerced by the Georgia Supreme Court in Winfrey, W-I-N-F-R-E-Y versus State 304, Georgia. And it says specifically in that case that that guilty plea is void, is null, and cannot be used for any purpose. We approached the predecessor judge, and he said he didn't know about that case. It's all on the record. It was at the bench. And I said, well, here's the site. And he said, well, I'm not going to read it. And I said, well, I'm going to cross him on it, and I'm going to subpoena the lawyers. And I put them on my witness list who entered that plea. And I have a certified copy of the Supreme Court opinion vacating it. And this predecessor judge said I couldn't do any of that. Ms. Hilton then came back to the podium and asked Agent Racy the next series of questions. Well, was that plea, for whatever reason, vacated? And a short time later, did Mr. Winfrey enter a guilty plea? I again objected. I was not allowed to go into it. The essence of this motion, number 62 of Mr. Williams, is I believe that that's already a constitutional violation. So it has to be harmless beyond a reasonable doubt. Because
Was there any kind of instruction?
no,
Okay.
no, it was, I can't cross on it. Mr. Matthews can't cross on it. We were all barred. And it came out that way, that Mr. Winfrey pled guilty. And this dealt with the April 26, 2015 tour bus shooting of a gentleman named Dwayne Carter. He's a phenomenal artist, musical artist, known as Lil Wayne. So the state gets that in. Now, the predecessor judge did keep out the indictment on my objection, because the indictment names as co-conspirators, unindicted co-conspirators, Mr. Williams in that event, and it was a RICO count. The further objection was that Mr. Winfrey, he didn't really plead guilty. This is the most favorable Alford plea, and I attached it to Mr. Williams' number 62 that, that I have seen, where the predecessor judge specifically, excuse me, not the predecessor judge, Judge Staley, it's S-T-A-L-E-Y, and Staley Clark, C-L-A-R-K, Cobb County Superior Court. She specifically acknowledges that this is not a guilty plea. This is a best interest plea. He's not entering admission of guilt. The Honorable Steve Sadow, which was the lawyer, he specifically said that we are doing this just because it's been 5 years and Mr. Winfrey wants to get out of custody. And I attached that, and I have a certified copy of that Alford plea. Anyway, the way it came in was so wrong, and we had cases that we were citing to the predecessor judge explaining that a person who's not testifying, the fact that they pled guilty, people plead guilty for any numerous reasons, should not be allowed to come in against Mr. Williams and the others here. So going forward, I put this on this honorable court's radar because it is my belief and understanding, and if it's not going to happen, that's great, that Mr. Kendrick has pled guilty to being in a criminal street gang, specifically YSL, when he was with Mr. Martinez-Arnold. Martinez-Arnold is going to be a witness, but he did not plead guilty to that charge. And it's my understanding that the state intends to have an exhibit, a certified copy of the guilty plea of Mr. Kendrick. And that should not come in against Mr. Williams or any of the other people here for the same reason.
Let me stop and ask the state, is your position?
Now, what's interesting with that whole situation is that the state knew this going in, so did the previous judge, who allowed the evidence in from the beginning when the defense was actually objecting. Now, y'all knew that this actual evidence with the Lil Wayne bus incident had no connection to the actual YSL, actual RICO case. Not on the indictment, and to make it even sick, the actual plea was overturned by the Supreme Court. So if the Supreme Court's overturned this plea and they deemed it as being coerced, why would the judge actually allow that evidence in and limit the defense to actually saying what really happened? They did that just to continue to help shape and paint the state's narrative. They had YSL enhance a shooting, Lil Wayne, see the connection, but did the state fail to connect the dots? Let's dig.
is your position that it comes in against anybody other than Mr. Kendrick?
I don't believe that a certified copy of Kendrick's conviction would be admissible against another defendant besides Kendrick. And additionally, we intentionally did not tender the certified for Jimmy Winfrey.
For Mr. Winfrey?
Correct. The court did not preclude us. We did not tender it.
Right. Okay, so is it the state's position that not the certified copy of the conviction, but the fact of Mr. Kendrick pleading guilty to, it was gang activity and the gang being YSL, what's the state's position on that with regard to that information coming in on anybody else?
I think that his guilty plea, the fact of his guilty plea, is admissible against him, and I don't believe that it's admissible in normal cases against anyone else. In this circumstance, I also don't believe that it is. At this time, I don't believe the cases that I've read suggest that it would not be admissible against another defendant. That's
all right. I mean, I think that's generally correct. So I think I've mentioned before needing a limiting instruction, and I know we're not quite at that stage yet, but I don't know when you intend to introduce that. And
not for the next 2 weeks, I believe.
Okay. Well, can you go ahead and be trying to put together whatever appropriate limiting instruction there would be? And then I would think that the position of both the defense and the state would be the same with regard to Mr. Ryan's murder jury verdict. To the next folder, there's a 911 call? Okay, what's that?
So, Your Honor, there's a single 911 call and a CAD report. There was a shooting the night before at Waters Road, and the caller notices that her vehicle window is shot out the day that she's making this call. And so it's a brief 911 call where she's calling to let them know that her car window has been shot out. She doesn't know who shot her car window out, but she's calling the police when she walks outside and notices her vehicle in her driveway with the window shot out from a bullet. And so the objection was confrontation clause and hearsay because it's not an ongoing emergency. The state's position is it's not a confrontation clause issue because she is not making this phone call for purposes of future prosecution. She doesn't even know who did it or give her thoughts of who might have done it. And in terms of hearsay, although the shooting itself happens prior to her walking out and seeing her window, the state feels that there's two reasons of a hearsay exception. One being a present sense impression in terms of she walks outside, notices her car window is shattered from a bullet, and she calls 911. And two, in her mind, even though her demeanor on the call, which is not dispositive of if it's an excited utterance or not, but seeing your car window shot out is to me something that would reasonably generate some level of excitement in a reasonable person. And so she's very calm on the call in terms of her voice, but the state feels that either a present sense impression and or an excited utterance for calling the police satisfies the hearsay exception. And that's the state's position in terms of the 911 audio, Your Honor.
Okay, and then is the Waters Road shooting, there's other evidence of that, right?
Yes, Your Honor. So, Your Honor, there's multiple shootings at that address.
Okay, the Waters Road shooting from March 12th, 2022.
Yes, Your Honor. And so this 911 call and her CAD report, when she calls to report her window being shot, is the court asking if we're going to call the responding officer who went to examine her car, or?
No, I mean, the evidence is in or is going to be in that there was a shooting at Waters Road on March 12th, 2023. I guess I'm wondering, because of the length of this trial already, and it's apparent, I mean, we're going to have to talk about how much longer y'all think this is going to take. But what does it add, I guess, that somebody else's window got shot out?
So Your Honor, this is all intimately wrapped into the Shamel Drinks murder, where Mr. Ford and Mr. McMiller are murdered by who YSL believes is YFN members, if gang members, the same group in 2022 that's tethered to Donovan Thomas's group in 2015 in the murder we're on currently. And what the wiretaps we played earlier, where there was conversation, and by earlier I mean a couple weeks ago, where there was guns in the attic, when they're all hiding and they're running outside, and we played that is Waters Road. So there's a number of shootings that we believe was from YFN at YSL. And so this 911 call is a innocent victim of that in terms of not the intended target whose window is shot out and calls police, and her, I believe, either boyfriend or husband, Mr. Whetstone, is going to be a witness we will be calling. So the state wanted to, this chronological or timeline is important. It's a brief 911 call, and there's obviously an accompanying CAD report, so the state feels that it's relevant for the jury because they need to understand this sequence of events in terms of the back and forth shooting and what transpires.
Okay, but do they need to know that somebody who had their car parked on the street or wherever it was parked, a stray bullet hit them?
It's right.
It hit their car, not them, their car?
So, Your Honor, in terms of the relevancy and the low legal standard of it,
I'm not saying it's not relevant. Do you need it?
the state believes we do, and it's.
Okay, y'all are going to have to start picking some stuff that you just, I mean, this case can't go on forever. It feels like it's going on forever, but there's got to be something that y'all can say, you know what, I think we ought to be able to prove our case without that. And this kind of seems like one of those things. And I know that there's not, there may or may not, well, I think there's just kind of a standing cumulative waste of time objection by the defense. But
It's a hard question to answer.
I know.
And so the state felt that in terms of brevity or this short 911 call and CAD report anchors the timeline for the jury and is helpful. The state's not intending on calling the officer who responded to check her window.
Good. Okay.
And so the state felt that this was I believe Ms. Latners could testify about these two items in probably under 5 minutes.
She probably can, but 5 minutes here and 5 minutes there and 10 minutes the other place. If she's already going to be testifying to 911 calls that came in closer to time, is she going to be doing that?
She's going to be handling a number of 911 calls and CADs, Your Honor, that tether both the Shamel Drinks murder, the murder of Mr. Ford and Mr. McMiller, and the multiple shootings at Waters Road, one of which this is a 911 call in response to.
So is there going to be other evidence that either has come in or will come in that this shooting at Waters Road occurred on March 12th of 2022?
One brief moment, Your Honor.
Okay.
So yeah, is it safe to say that the state has been wasting time? The motion filed by the prosecutor last night, signed by Fannie Willis, waste of time. The evidence that y'all keep on bringing in, it's a waste of time. You know why it's a waste of time? Because you still haven't shown the correlation of the furtherance, the enhancement of the RICO. You haven't shown any motive. You haven't shown the conspiracy. You haven't proven the gang ties. You haven't proven any of the stuff that you're alleging with this actual trial. Is YSL even responsible for none at this point? Now, it's interesting because as the judge keeps asking them with this evidence that we're actually about to see and be presented in front of the jury, can we simplify it and make it make sense? The interesting thing is they can't even simplify it, and when they do simplify it, it doesn't make sense. Let's dig.
CAD.
This is the way y'all are introducing that the shooting occurred at Waters Road on March 12th?
There's two different shootings.
And there's two different shootings, Your Honor, but in terms of her
When's
car
the
window
other
being
shooting?
shot out, March 16th.
Okay, so let's not worry about that one. March 12th. This is the only way that y'all are establishing a shooting at Waters Road on March 12th, yes or no?
Yes, Your Honor. The state can call other witnesses or evidence about that shooting, but we intended to call and introduce this CAD report 911 currently.
I understand that y'all want to. Was that the only evidence that y'all were going to put up that this occurred on March 12th? Was this 911 call and boyfriend or husband and the discovery that on March 13th this window was shot out? That's how y'all are going to establish a shooting on March 12th?
In order to cut down witnesses, Your Honor, we have other witnesses. We could call Ms. Zachary, we could call the responding officer, but in order to shorten, we get the complaint that we need to shorten the case. And so what we're trying to do is there's a 911 call. There's two 911 calls. There's a 911 call from March 12th.
Okay, are you planning to introduce that?
Yes, that's the day before.
Okay, but after the shooting occurs, correct?
The 911 calls, as the shooting occurs, the woman is in her house and she's like, they're shooting down my street.
Okay,
Yes.
so why isn't that enough?
Because this was the further evidence of that. So that's why we're playing the two 911 calls, because the March 12th call, right, there shows that she called, the first caller never went outside, all she says is there's shots fired. On March 13th, when that witness goes outside, she sees that her car has been riddled by bullets. Now there's additional evidence that Ms. Zachary would bring in that her daughter heard the gunshots the night before, but we're not bringing that in. So what we're trying to do is tie in the first call from March 12th and then the call from March 13th. There's more evidence, but we're trying to, as best, get in what is relevant to establish that there was a shooting. Again, all of these shootings are in response to what happens in February with Wyatt and Lucci getting stabbed.
Is it riddled with bullets?
When you say, excuse me, maybe I shouldn't say riddled with bullets, but there are bullet holes.
So y'all remember, in all of my videos, I tell you what the state does is they play on verbiage. You heard how the judge just caught that? The vehicle is riddled with bullets. Now, if you hear that, it's crazy. It sounds bad, sounds dramatic, sounds horrible, right? Just to be transparent. But then if you turn around and actually go and read and hear how it actually broke down, it was one shot through a window. No suspect, no witnesses, no fingerprints, no shell casing, busted glass. So where does the term riddled with bullets come from? See, another example, right here in front of the judge, no jury. You think the jury not paying attention to this? See another pure example of how the state misrepresents information? Now, if you heard that and you were in the jury box, that would actually make you look at these defendants and cast that, like, God, they going in. But then you turn around and they actually read the paper like it was one shot and none of them was even attached to it. Matter of fact, nobody was arrested from over here that's on trial. Nobody was questioned about this that's on trial. Nobody was charged with this that's on trial. As a matter of fact, it's just an event that's in an indictment that none of them are attached to, but we believe it was done. This is what we're doing. So again, I'm gonna ask, where's the furtherance? Where's the RICO? Where's the conspiracy? The conspiracy is the state's narrative with this whole YSL case. Let's dig.
Or group of people?
A particular group of people, and again, the nature, the type of traffic, if you will,
Meaning?
the house.
Meaning what?
He will not be saying, oh, there's drug dealing going on at the house, but just the frequency of different visitors to the house, the vehicles he observed at the house.
And the vehicles are going to be tied to?
What YSL members, yeah. Well, one in particular belongs to Mr. Williams, for instance. For instance, I'll leave it there.
Okay. Well, if he is going to be able to testify to seeing particular vehicles with, whatever frequency he's going to testify to, and there's something that ties those vehicles to these defendants or other YSL members, then that seems irrelevant. So.
Thank you, Your Honor. And yes, it was the Waters Road, obviously, the court has heard us say before, is a YSL spot.
Right.
And the shootings and the activity at the house.
Right.
Yes.
Okay.
Yo, stop what you're doing real quick. Hit that like button and subscribe to the channel. It's free. Hit the like button. Share the video. Hit the like button. Let's dig.
And Judge, I'll just, while the court is looking at the indictment, where he is displaying prominently that center tattoo on his person of YSL, obviously, along with all the others, and making that post. The fact of the posing on social media with the gang name in the middle and slime for life on his arm, and asserting publicly chasing that money, but his past chasing him, we would argue reflects at least part of what we are alleging that the gang has done or does in furtherance of the enterprise itself, obtaining money and property through a pattern of racketeering activity. Him chasing that money, but his past chasing me, we would argue suggests that he has done things that were not legal. And this is an argument, this is one, obviously, that could be made at the end. The jury could infer from what they are seeing many things, but particularly we posted, or we named this as an overt act, number 126.
Okay, and that was posing for the photo that he put on his account, displaying gang tattoos, not the post, not the language. What you put in the indictment is
the description of it, yeah, the description of what happened. He posed.
In post for a photo released on someone's Instagram account displaying gang tattoos with YSL on his chest and slime for life on his right arm, an overt act in furtherance of the conspiracy.
Right, and the language, the language further shows how he is furthering the conspiracy
How
by
is
saying
that furthering the conspiracy?
chasing that money, but his past chasing him suggests that he not only does things or has done things that perhaps in chasing that money, they're not legal. He is continuing to chase that money in ways that are not legal.
What suggests that he is doing anything illegal by chasing that money?
Your Honor,
Is that what pretty much all of us who aren't independently wealthy have to do every day of our lives?
So again, what did we just witness? Another misrepresentation of evidence from the state. Now it's interesting all day. The defense went back and forth with different motions from the state. The state went back and forth with the judge. But ultimately today was definitely a W for the defense. Now there were a few pieces of key evidence that the actual judge did let in, such as the lyrics, personal opinion. It's going to be beautiful when they actually get into arguing the information over the lyrics, because the state has been misrepresenting information the entire time. So ask yourself, is it safe to say that it's a better gamble to say that they misinterpreted the information again? Not to mention, Matt Shaw went in all day with the different phone calls that came out from the different defendants while they were playing all this information about the irrelevant stuff again with phone calls. Ask yourself, what did we learn today? We learned that loyalty doesn't exist among thieves. That's the only thing in my personal opinion that I actually say that we learned. There's no loyalty with any of these actual associates or fellow members or whatever the state wants to allege them to be. There's no loyalty amongst them. So if I was Thug, would you have cut them off too? Started creating distance and separation? If Thug is such this mob boss ordering hits and everything's happening through the streets and he's making this one go do that and this one go do that and this, that, you don't think he knew that all these people were talking on the jail phones and cooperating and taking pleas and working with the police down in Atlanta and different investigators? Why not drop the money on them and start making them disappear? No evidence would actually be easier to fight. Man, what did we learn from the trial today? That the state has definitely been wasting time. Too much evidence allowed in. Then the judge. We all knew that Judge G assisted the state, letting in specific pieces of evidence that the defense was definitely objecting on. Why did he do that? Just to help shape the state's narrative. Was he the actual puppet master who was pulling the strings behind the scene? Let that sink in. Did the judge actually get the rulings fair today? Even though she did actually let some information in from the state, in my personal opinion, it'll be in favor of the defense either way. Now, there is a lot of parts that we didn't actually touch on because, again, why work on the stuff that's not relevant to the actual viewer, to the actual case, and to the actual trial? Paperwork, partner. Complete waste of time. Man, y'all know the vibes. I'm your host, Jay. Until next time, remember, the life you save might be your very own. Gone.